That helps, doesn't it? Helps to have some volume on. Well, Smiley, keep the beast in a little lattice box, and he used to fetch him downtown sometimes and lay for a bet. One day a fella, a stranger in the camp he was, come across him with his box and says, "What might it be that you've got in the box?" And Smiley says, sort of indifferent like, "It might be a parrot, or it might be a canary. Maybe, but it ain't. It's only just a frog." And the fella took it and looked at it careful and turned it round this way and that and says, so's 'tis. Well, what's he good for?" "Well," Smiley says, easy and careless, "he's good enough for one thing. I should judge he can outjump any frog in Calaveras County." The fella took the box again and took another long particular look and give it back to Smiley and says, very deliberate, "Well," he says, "I don't see no pints about that frog that's any better than any frog." "Maybe you don't," Smiley says. "Maybe you understand frogs and maybe you don't understand them. Maybe you've never had experience and maybe you ain't only an amateur, as it were. Anyways, I've got my opinion and I'll risk $40 that he can outjump any frog in Calaveras County." Right, this is going to be a quick one. I'll just check that you can hear me. That all looks good. Is that good? Stream health. Excellent. Right. Okay. Away we go then. We got a motion to look at. It's going to be very quick. So, and I'm going to read it and get out of here because it's late and I want to go to bed. So, here we go. So it's United States v. Christopher J. Cordova. And it's an order by the United States Magistrates Judge. After holding a bench trial in this matter of March 20, 2023, the court found defendant guilty on both counts charged in the information. 1. Failing to comply with official signs of a prohibitory, regulatory and directory nature and with lawful direction of federal police officers and other authorised individuals under that section of 41 CFR, and 2, unlawfully photographing federal property under that section of 41 CFR. At the September 27, 2023 sentencing hearing, the court issued a sentence of 15 days in the custody of the Federal Bureau of Prisons on count 1, 2 years of probation on count 2, and a $3,000 fine. At the hearing, defendant requested the court stay his sentence pending his appeal of his conviction. The court withheld the formal entry of judgment pending its ruling on its motion to stay. At the court's directions, the parties have briefed the issue. As set forth below, the court grants the motion to stay. So if you want to leave me here, that's the answer. It's pretty good analysis, though. So, analysis in terms of, fairness in a legal system. With respect to petty offence cases, Federal Rule of Criminal Procedure 38 applies to a stay of a judgment of a conviction or sentence. It provides the court with discretion to stay a sentence of probation or to pay a fine. Citation: if the defendant appeals, the court may stay a sentence to pay a fine or a fine and costs on any terms considered appropriate. Another citation: if the defendant appeals, the court may stay a sentence of probation. The court must set the terms of any stay. The only mandate with respect to a sentence of imprisonment is that a stay is required if the court releases the defendant pending appeal. And there's citation: if the defendant is released pending appeal, the court must stay a sentence of imprisonment. And there's a citation. If the defendant is not released pending appeal, the court may recommend to the Attorney General that the defendant be confined near the place of the trial or appeal for a period reasonably necessary to permit the defendant to assist in preparing the appeal. Defendant argues that 18 U.S.C. 3143 provides the standard for determining whether to stay a conviction or sentence on appeal. Section 3143 (b) 1 provides the standard for release or detention pending an appeal by a defendant, specifically one who has been found guilty of an offence and sentenced to a term of imprisonment, and who has filed an appeal or a petition for writ of certiorari. Sorry, it's late. But an offence as used in this section is defined as any federal criminal offence which is in violation of any act of Congress and is triable by any court established by Act of Congress (brackets other than a Class B or C misdemeanor). Citation. Because defendant has been convicted of 2 Class C misdemeanors, that section does not apply here. Citation. The term petty offence means a Class B misdemeanor, a Class C misdemeanor, or an infraction. Contrastingly, the government urged the court to apply the factors set forth in F.UK.T v. Holder. As the Supreme Court noted in that case, it is well established that a stay is an exercise of judicial discretion. Citation. A federal court can stay the enforcement of a judgment pending the outcome of an appeal. Citation. Indeed, a stay is not a matter of right, even if irreparable injury might otherwise result. Citation. The party requesting a stay bears the burden of showing that the circumstances justify an exercise of that discretion. Citation. The 4 F.UK.T factors for determining whether to grant a stay are as follows. 1. Whether the stay applicant has made a strong showing that he is likely to succeed on the merits. 2. Whether the applicant will be irreparably injured absent a stay. 3. Whether issuance of the stay will substantially injure the other parties interested in the proceeding. And 4. Where the public interest lies. Citations. The first 2 are the most critical. The court finds the second factor, one of the most important factors, warrants a stay. The government argues that defendant proffers 2 bases for his appeal, both relating solely to count 2, and because appellate success would not affect defendant's prison term, he cannot show irreparable harm from an order to serve that term while he appeals. The court disagrees. Defendant's motion clearly states 3 appeal arguments. 1. That the regulations at issue in this case are violations of his First Amendment right to record in public facilities. 2. That the area in which the defendant recorded was a lobby for the purpose of 41 CFR. And 3. In sentencing, the court improperly relied upon charges for state-level crimes for which defendant has not been convicted in determining its sentence. The third argument applies to defendant's imprisonment sentence for count 1. Indeed, defence counsel raised this argument at the sentencing hearing in opposing the government's recommendation changing from community service to jail sentence. Because it is highly unlikely that defendant's appeal would be resolved before he completed his 15-day jail sentence, success on appeal would result in irreparable harm. Notably, the government's motion seemingly concedes this point. Moreover, defendant proffered financial difficulties at the sentencing hearing. Similarly support irreparable harm as to payment of the $3,000 fine, payment of which is mandatory condition of the probation sentence. Even if defendant has not made a strong showing of success on the merits, the court finds the rest of the F.UK.T factors favour a stay of defendant's sentence in its entirety. The court does not find substantial injury to other parties interested in this proceeding. It also finds that the public's interest is the fair and just adjudication of judicial, particularly criminal proceedings, warrants allowing the resolution of defendant's appeal to a district judge before imposing the sentence, especially imprisonment. On balance, the court finds a complete stay of defendant's sentence pending his appeal to a district judge is appropriate under the I got excited then because I was getting to the unken factors. I love the way I can say unken. Conclusion. For the foregoing reasons, the court grants defendant's motion to stay a sentence. Accordingly, the court stays defendant's sentence pending the resolution of his appeal to a district judge and directs the clerk of court to enter judgment against the defendant. So that was entered on the 19th. It's the 20th here, but it's the 19th for most of you. So that brings you up to date with DMA. I actually think it's a well-reasoned judgment. We might want him to go to jail straight away, but in terms of the irreparable harm argument, it's probably fair. So I don't think we can complain too much, however much you want him to meet Big Bubba. Now, I did say I was going to finish straight away. Anyone who's come in, it's late. I thought I'd go live just to bring you that. I'm not even set up to interact with my chat. I went live so quickly. I see quite a number of names there. I'm just seeing if there's one in particular. I can't see him. No. As one or two people in chat are aware, I got some I have something to look forward to in early to mid-November. Perhaps I'll tell you about it at some point. Anyway, thanks for joining me. I have a video actually ready to go on Chile at a county commissioners meeting, which he made the press. Oh, there he is. Oh, no, I shouldn't. No, mustn't give too much away yet. But nice to see you, whoever you may be. And I'll be seeing you shortly. Anyhow, good night. Thanks for watching.